going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Tuesday. Hope you guys are all having a great day. Hope you guys all had a great day. It's 8 o'clock now. Day's kind of over. All right. I've got some good ones for you. I've got 2 clips of attorneys getting into trouble. Got one in Judge Gauthier's and then one in Judge Simpson. Judge Gauthier one happened, I think, on Thursday or Friday. Judge Simpson one happened today. And then I just end with some kind of dumb defendants. But yeah. Let's watch some attorneys get yelled at for a little bit, shall we? All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Good morning. All right. And there's an attorney, Kennedy Shannon. Do you know what that is? That on this case or no?
Yes, with my office.
Oh, okay. All right. Well, good morning. We are on the record in the 53rd Circuit Court for the County of Sheboygan, continuing our civil docket, and we are providing public access both in the courtroom and also online. And up next, I've got a motion for summary disposition in Estate of Wiggins v. Wiggins, filed 24-9024CH. Counsel, you want to state your appearances, please, beginning with the plaintiff?
Oh, excuse me, Laura McMahon Lynch, appearing on behalf of the plaintiffs, Amelia Wiggins, and estate of Betty Geraldine Wiggins.
Good morning, Your Honor. Alexandria Taylor on behalf of the defendants.
Okay, good morning. And this is your motion for summary disposition, Ms. Taylor. Before you get into your argument, I have just a couple quick questions for you. One is, because looking at the file, I've got all these motions for alternate service that have been filed and whatnot. How many of these defendants and which of them do you represent?
So, Your Honor, I represent the family of Jacqueline Wiggins and of Anna. Theron is deceased.
Well, hang on.
Yes.
Hang on. So family of.
Hey, Biggin, I appreciate that, buddy. I appreciate that. And welcome to all the Biggin Raiders. You're awesome, buddy. All the Raiders are awesome too, but you know, big guy's more awesomer. No, he's not. We're all equal awesome. You guys know what I'm saying. But yeah, I seriously appreciate that. And yeah, again, everyone here is already subscribed over there. But if someone could drop his link, I would appreciate that. Heather. Hi, Heather. Member for 8 months. The original member. 8 months. We're up to 8 months now. That is awesome. Thanks, Heather. I appreciate it, babe.
Okay, so if I'm looking at the case caption, and I'm sorry, I just didn't go through and look at all of the. I mean, when you file the motion and it says you're the attorney for defendants, can we go through the caption and you can clarify for me which of the defendants you represent then? Gail Wiggins?
Hold on 1 second, Your Honor. Yes, Gail Wiggins.
Okay. Kai Smith?
Yes.
Kim Savage?
All right, I was going to wait a little bit to pause again, but geez, Legal Fiction, bringing the heat. Thank you so much. That is extremely generous. Legal Fiction with the 20 gifted memberships. Thank you so much, buddy. I appreciate it. That's very generous of you. While I'm paused, Jason, thank you so much for the 4 months. That is awesome, bud. I appreciate it. All right, thank you both, and let's keep going.
Yes.
Donna Wiggins?
Yes.
Daryl Wiggins?
Yes.
Christina Wiggins?
Yes.
Anna Bolden?
Yes.
Reginald Wiggins?
Yes.
Ronald Wiggins?
Yes.
Victoria Thrasher?
Yes.
Cheryl Adams,
Yes.
estate of Cynthia Ruffin.
Cynthia Wiggins, yes.
Okay. Estate of Leonard Wiggins,
Yes.
estate of Theron Wiggins.
No.
Okay. Estate of Irvin Wiggins
Yes.
and estate of Jacqueline Wiggins.
Yes.
Okay, so you represent all the defendants except the estate of Theron Wiggins, is that right?
Yes.
Okay, and Ms. Lynch, is that consistent with your understanding of the status of the case in terms of service and representation?
You know,
I mean,
I take exception with that.
Yeah, because I signed an order yesterday where you're saying I need alternate service on Reginald Wiggins. And Ms. Taylor's saying she's representing him.
We had a conversation, Your Honor, some weeks ago, and she said she had a spokesman for the Wiggins family. I have drafted a motion to disclose her retention agreements because I don't understand her representation of estates that have no personal representative. Her response on the phone about that was that she had to consult with her probate attorney. But just as a matter of course, I don't think there's any authority for her to be representing estates absent some kind of court order. With regard to, there is one error in the caption that you read off. And that is also a housekeeping matter that I was going to seek some direction on. There is another defendant who is Edward Ruffin, who is the husband of the deceased Cynthia Ruffin. He is named in the verified complaint and in the first amended verified complaint as a defendant. A summons was issued from the verified complaint. He was served, proof served, filed. So I asked about Mr. Ruffin, and counsel was asking me for his contact information because there have been settlement offers, and pursuant to MCR PC 1.4, the offer of settlement should be made to each defendant.
Okay, well,
They should be aware of what's being offered. The fact that she wants me to give her the contact information for a defendant she's supposedly representing is troublesome to me.
all right, so before we,
The judge is about to clear it up a little bit. I don't know a lot of the backstory of this case, but these attorneys don't like each other. They're arguing over the estate of somebody, I believe. So it's a civil case, and yeah, we're about to hear how Judge Gauthier likes these two attorneys and how they file motions and paperwork. So he'll clear it up a little bit for us right now. Well, within the rest of the video.
go any further then, I just want to clarify this then. So Ms. Taylor, there's no answer that's been filed, right? Your motion for summary disposition is the responsive pleading you're filing. Am I right?
That is correct, Your Honor.
Okay, so there's all the
Hey, happy birthday! Sorry, I walked away for about 10 seconds and I came back and I was trying to catch up on the chat. Happy birthday! I appreciate it. Yeah, I always pause for birthdays. Well, at least when I see them, and I almost miss yours. So thank you for spending your birthday with us. And I hope you have a better rest of the evening. Hang out with us and have fun.
these defendants, some of them estates, and I'm signing orders for alternate service. And so you didn't file like an appearance, did you, for who you're representing? You just filed the motion for summary disposition as a responsive pleading. Am I correct about that?
Yes, Your Honor. And if I can comment, so when counsel communicated the settlement was as to all defendants. And so it wasn't just a settlement as to one family. She communicated that as to all. And then I had a communication with the individuals. I don't recall what counsel is speaking about. She communicated
Okay,
that.
well, I don't care
If I
about,
could just speak to the,
hang on. I don't care about the settlement stuff. Here's what I care about. I've got a case with like more than a dozen defendants. I've got all these motions and orders for alternate service out here that I'm signing. And so the plaintiff is saying they don't even have some parties served. I get a defense. I don't get an appearance or an answer from any of the defendants. I get a pleading filed by Ms. Taylor that says it's a motion for summary disposition. And she just says she's the attorney for defendants, but doesn't tell me which ones. And then I ask what ought to be a simple question. Which defendants does Ms. Taylor represent? And I'm not getting any clear answer from the two attorneys. I like to use this line sometimes. I'll use it today. There are many mysteries in the universe. Who a lawyer represents ought not be one of them. I can't see how I can possibly proceed today, Ms. Taylor, with me not even knowing who's this motion for summary disposition filed on behalf of. My second issue to you is then there's a motion, then there was an amended complaint filed after your motion. Does that require you to amend your motion or render it moot in any way, or where are we at on that?
Well, Your Honor, first of all, and then my co-counsel can speak to it. But when we went through the list, Your Honor went through the list and asked me, and then I said yes to the ones that I did represent. So I'm sorry if there was some misunderstanding in that.
The caption on your pleading left one of them off, right?
Yeah.
So Edward Ruffin. So the caption, you file a motion disposition saying for defendants.
Yes.
And you don't, and it doesn't say which defendants you're representing. I find out today it's not all of them. And then the caption that you had on your pleading leaves one of the defendants off. So, I mean, do you understand where I'm coming from? I mean, I need to know, let's say I grant your motion. I need to know what portions of the case are being adjudicated and what portions of the case may yet be alive, don't I?
Yes. And the second thing, Your Honor, pursuant to the court rule, I thought that you had to do motion for leave to file an amendment because we've answered it. And so that.
No, well, I don't know who's answered it.
Your Honor.
Let me ask you this.
Your Honor, can my co-counsel speak?
Your Honor, Kennedy.
No,
I'm sorry.
I mean, I'd prefer.
Can I make a response, Your Honor? First of all, it's not a responsive pleading. A
Well, it
motion
is.
is
A
not
motion
a
for summary
responsive pleading.
disposition can be filed in lieu of one, yeah.
Right, but under 2.110, a pleading is either a complaint, a cross complaint, a counter complaint, a third party complaint, or an answer to one of those. So I had perfect right to amend the complaint without any leave because no responsive pleading has been filed at this moment under 2.118.
Oh, it's even wilder than that. Her co-counsel is the named attorney. This Miss Taylor just works in the same. Like, I think it might be her co-counsel's. She might be the boss, and she's coming in like, oh, this is a lot more complicated than I thought it was. So she stepped in, but her co-counsel is the one who judge thought was the attorney on record. She steps in because it's her law firm is on record, so she can do that. But yeah, it's been a mess since the beginning. No one knows what's going on. Well, the judge doesn't know what's going on. The attorneys don't know, and they're catfighting.
But that is a
Your Honor, if I might.
Let's maybe set aside my procedural problems with this and just get to the merits of your motion, Ms. Taylor. When I read your brief, isn't your brief just a whole bunch of factual disputations? And how could that possibly be the basis for summary disposition prior to discovery? The plaintiff filed this complaint, and your motion for summary disposition just says, no, it's all these other facts instead. How is this ripe for summary disposition today?
Well, Your Honor, there are no facts in dispute on the ownership. That's a legal question. So that is not in dispute, Your Honor. And second, there is an open probate case. And so probate court is a court to decide interest. And so that's the other thing. I mean, this to me is improperly before this court because I confirmed that the probate matter is still open. And so if there is a question as to the interest in a decedent's estate, that is a matter that is best handled by the probate court.
Bob, I did see it, and that case is actually next. which is why I titled this "Attorneys Getting Scolded by the Judge." Because these two attorneys, it already started, but he keeps going. He keeps going. Welcome, Miranda. I'm glad you made it. I'm glad you made it. I know I've got some super chat. Rich, thank you so much. I'll call you guys out properly in between the clips.
Right, but, I mean, you haven't attached a single exhibit or documentary or citation really to any record anywhere in your motion or brief.
We did have exhibits on there, and there is case law, Your Honor. So when you say there's no citations, what citations are you referring to?
No, citations to the record. So there's these exhibits, but you don't.
Right, I was going to say, because if there aren't any exhibits, then that's a mistake, because what I'm bringing up is 34 pages that were filed. And there are exhibits that are filed in there, and there are case law citations as well.
Sure, but where in your motion or brief do you make a citation to any of those specific exhibits? I see none.
In the
But
motion.
clearly what's that?
I'm sorry, what did you say, Your Honor?
Well, I mean, clearly you and Miss Lynch know a lot about the facts of these folks. And
Are you talking about my name or the channel name? The channel name is cool with Colin, but my name is Colin, definitely not Cromwell. So is that what you're referring to? I'll tell that story in between clips as well.
I know none of those things. So when I read a motion filed by an attorney and your motion has 15 numbered paragraphs and not one of them makes reference to, it just says, see attached exhibit A, emails and payment of expenses. That's the only citation to a record that doesn't like point me to specific things in it. And then there's a brief that's very, very short, like 4 or 5 pages. Again, no reference to anything specific in the exhibits, and then a stack of exhibits. I guess your pleadings, I don't know these folks, I don't know these facts, and I can't possibly know what to do with this case by reading your motion or brief. What is it you'd like me to do today, Ms. Taylor?
Well, Your Honor, what we would like you to do is to dismiss this case, because there is no legal question. There is no issue of the law here. The deed is clear in that there was a 25% interest to 4 individuals, and this is a family cabin. And this is something that was acknowledged by.
So what deed? You filed a motion for summary disposition. You don't even attach the deed and point that out.
But the deed was attached to plaintiff's complaint, Your Honor. So that's the deed that I'm referencing, is in plaintiff's complaint. The deed that plaintiff attached, there's no question as to this deed and the interest, and it's simply that plaintiff wants to take the property, this family property, and essentially disinherit 40 family members. And so there is no legal question. And so the things that were argued, the categories in plaintiff's complaint, those categories are addressed in the motion. The unjust enrichment, which plaintiff is arguing that there's going to be unjust enrichment because her mother paid all the expenses for the cabin. Well, that's the exhibits. The exhibits show that simply did not happen. And that actually covers their point, count 1 and 2 for contribution. The adverse possession, we cite the law, is the legal argument, why that argument fails. And then the quiet title, which is subsection
Right, you cite the argument, you cite an argument about adverse possession, but then you just tell me a bunch of facts. How do I know if there's a true? Isn't that what litigation is for? You don't get to just file a motion with a bunch of factual assertions with no record evidence and then expect the judge to make the case go away for you. I'm going to deny the motion for summary disposition. It's a confusing mess. I don't even know if it's filed under C8 or C10. I don't know which defendants Ms. Taylor is representing. And the motion and brief would leave it to this court to research and ascertain the facts and the legal theories behind the defendant's motion. I consider all those arguments abandoned for inadequate briefing. the motion's dismissed or the motion's denied without prejudice.
Your
So it
Honor,
being refiled later.
may I raise one issue?
There's nothing before me out yet today.
Well, it is in my brief. We asked for judgment pursuant to
Same
I2.
issue. Your brief was just as bad. I have no idea. You both are filing briefs with me, just telling me a bunch of facts. I don't
I
get to
did
decide a
attach an
case just on what,
affidavit.
yeah, that's denied as well. You guys
right,
need to
thank
do
you,
a
Your
better
Honor.
job with your pleadings. Thank you.
Thank you.
Thank you, Your Honor.
All right. I don't know if I've ever seen Judge Gauthier get that frustrated. I mean, we've seen him cover South Sets. We've seen him cover a lot of cases that, you know, people interrupting him, and he always he doesn't always keep calm, but he does a really good job of keeping calm. But yet, two attorneys just got him to the point of like, I need a break. I need a break. All right, I need to catch up on some get some memberships. Steve, I'm gonna start here. I know I called out Legal Fiction. You know what? I'll do it again because it was so generous. Legal Fiction, once again, thank you so much, Legal Fiction. I appreciate it, buddy. That is extremely generous. Steve Bennett, thank you for the 2 months. That is awesome, buddy. And then we have Dick Harris for 6 months. 6 months. That's awesome, Rich. I appreciate it, Rich. And then with the $3 super sticker, Rich, you are awesome. I hope you're having a good night, buddy. I hope you're having a good night over there in the England area. Oh, and we got Lexa. We're just piling it on. Lexa, good to see you tonight. Twop Waffles Assemble. I think we got most of them here. I don't think all of you are here yet, but most of them. But Lexa, it's really good to see you. I hope you're doing okay. I hope you're doing okay. I'm not going to go into anything, but I hope you're doing okay. All right. I promised you the story behind my name. I've said this quite a few times now, so I think I've got it down to a 30-second story instead of a 10-minute story. Back when I first started watching Irish Demon. So for you that don't know, Irish Demon is another YouTuber content creator. And I was watching him, and I super chatted him once, and he called me Colin Cromwell because I used my generic YouTube name, and if you don't change your name, it's your first and last name by default. So he was calling me Colin Cromwell. This went on for a couple weeks until somebody told him, hey, you know that's not his name. So he just started calling me Colin, definitely not Cromwell, instead of my actual name. So as a joke, I changed it to this, intending on changing it back, and never did, and it stuck. So that was about 2 years ago, and this has been my name ever since. That's the story. So there we go. All right. Okay. Next case. Now we're going to the Judge Simpson case. And the judge, this one is yeah. Judge Simpson gets heated. We got an attorney that's in trouble. You guys may have seen this. I think I saw OSG posted. I think I saw someone else post it. But it's still a good one. Still a good one. And I got some fun ones after it. So hang out, even if you've seen it already. All right, let's go.
You may be seated. Back on the record in case of People's State of Michigan versus James Whitley. Typically, oh, go ahead.
Thank you. No full use on behalf of people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett, appeared with now Mr. Whitley sitting to my right.
Typically, the court doesn't publicly discuss, and I will apologize, Ms. Hughes, and I will allow certainly counsel to say what they want to say or need to say. The court doesn't discuss.
All right, I do want to quickly say I didn't play the first 10 seconds of the clip. Right before the bench conference, they called the case. So we called the case, and the very first thing the prosecutor said after making their appearances was, "Can we approach?" I don't have that part of it. It was literally 10 seconds, and me talking about it is longer than it actually was. So let's keep playing.
Bench conferences, but I think under these circumstances, I'm going to certainly disclose that unless Ms. Hughes, since it was your issue that you brought to the court, unless you have some strong objection to that.
I have no objection. Thank you.
The court has been informed that, at least alleged, that the defense counsel has indicated that should this exam begin, that it may be his intent to grieve the elected prosecutor for pursuing this case. Court has some concerns with that. First and foremost, that that posture in and of itself can have a chilling effect, not only on just proceedings and may be an attempt to interfere in these proceedings, which may in and of itself constitute a grievable offense, but also that this court, if that is indeed the allegation, would not proceed with a hearing that would require someone to then commit a grievable offense. And Ms. Hughes also disclosed to the court that she, in essence, went up her chain of command to seek their advice as to what she should do. It was ultimately said, I think, at one point to certainly bring it to the court's attention, which I think is appropriate since it's under. Mr. Bennett, I will ask you whether or not you believe, in this case, that the people in proceeding are committing a grievable offense. And if so, for you to state on the record what that offense is.
Does it look really big from your TV? Yeah, you could take that comment multiple ways. Good to see you, Bill.
Concern.
I'm not asking for your concern. I'm asking for you have made an accusation that know what?
I don't believe that they're committing a grievable offense.
Do you believe that in starting this exam that they would be committing a grievable offense?
No.
Was that said to the prosecutor?
That was said, I don't believe it was said in the manner that was described at the bench, but certainly.
Then tell me how it was said.
There were two things. One, at the bench, do you want me to ignore the one you didn't disclose?
All right, I'm going to add a little backstory because the last time that these two, this attorney and this defendant, were in front of Judge Simpson, the defense attorney asked for something about bond. I don't remember what it was. Maybe, I don't know if he has an ankle monitor. He might have asked to be taken off. Maybe he's testing and he tried to drop his testing. One of those things. And Judge Simpson said no. He's like, it was one of his, I don't even have to listen to the prosecutor. The answer is no. This defense attorney said, well, thank you so much for your consideration. Being a smartass to him. And Judge Simpson, was perfectly normal. He says that. He's like, no, you do not want to get that tone with me. Take your smart aleck somewhere else. Like, you do not want to do that with me. So Judge Simpson, I'm not going to say he doesn't like this attorney, but he's already tried. He's already tried to kind of undermine him before. Just seems kind of like a shady attorney. I don't know him. I'm not saying he is. Just kind of seems like it.
Tell me how it was said.
What I said is that I believe that if the state were to go forward, that it would be grievable because I believe that the prosecutor is not following through on their ethical obligations under the Michigan Rules of Professional Conduct.
Which ethical obligation are they not following for?
The two that I am concerned about are, one is determining what the actual facts are, and the two is prosecuting somebody who may in fact be actually innocent. What I did was I had offered Ms. Hughes, if she felt that it was appropriate, if she wanted to discuss the recanted note with the alleged victim, I said, why we could just adjourn this out and you can talk to her and decide how to go forward. So my only concern is that they didn't make contact with the alleged victim, who now has a different story, but I no longer believe that's a problem.
does that, even as you describe it, amount to something that is grievable?
It doesn't. But
And why was it said?
because at the time I believed that it was grievous.
What changed?
Quite honestly, what changed is I wasn't aware at the time that they had the lay witness here. And so the presence of the lay witnesses, I think, eliminates all of the issues I had with the police providing the testimony that's admissible here, but not in trial.
Ms. Hughes.
I absolutely intend on proceeding pursuant to MCL 76827C. I have made no statements to Mr. Bennett about Ms. Potter being present. But I don't think it is, because Ms. Potter is not present.
Explain.
I believe it's a DV case. I believe. I honestly don't even remember anymore. They spend this entire hearing about this defense attorney, but I believe it's a DV case.
To me, Mr. Bennett, how that makes a difference. Because quite frankly, I think your accusation is against the prosecutor. Amounts to your attempt to obstruct these proceedings. So explain to me, which in and of itself would be grievable, counsel. So explain to me what happened now that you know that they're there, how that changed the whole mindset.
The proceeding with statements that would exclusively be inadmissible at trial and going forward on those. These are confrontation clause issues.
There's a statute which covers that.
I understand that, Your Honor. My concern was it goes to circuit court on those statements, and now they can't proceed to trial. Because at that point, confrontation is going to attach at trial.
So why would that be grievable? If they proceed pursuant to a statute promulgated in the state, as well as a court rule, which covers that, why would that be grievable at any point?
My concern was not determining the facts of the case that they're going to present evidence in today.
If they believe those facts that, but for a hearsay objection, would come in, that not at all goes to their determination of the facts. They may believe that to be the case.
I understand.
So how would that even come into play? Mr. Bennett, how does that even come into play?
I explained what my position is. I don't know what else to say.
Okay, let me just say this. I don't care if somebody's on the defense side. I don't care if somebody's on the prosecution side. It doesn't matter to me, especially between counts. No one is ever going to come into this courtroom and be intimidated in some way by some threat to their profession, particularly in proceeding with what is their obligation. It is Ms. Hughes's obligation to bring this case. It is your obligation to defend your client. She can't make threats to you to try to prevent you from proceeding to defend your client, or to do nothing if your client wishes that for you to do that as the defendant. This behavior, Mr. Bennett, is inexcusable in this court's mind.
All right, this is not a good time to pause, but I wanted to answer this question. again, I'm not an attorney, so this is kind of my opinion and what I've learned by watching court. It's kind of almost a third party witness, and these are my words. Someone who is directly involved with the case, but it's not a lawyer. It might be like the best friend of somebody, because to prove probable cause, you need there's like 2 or 3 things. Like one of them's location, one of them's like you have to ID the witness. Like, are you the person? Did it happen here? So a lay witness may, connect one of those dots for the prosecution. That's again, that is my short-term version of it from what I've learned. I think I'm kind of close, but I might not be spot on. Hopefully that helps a little. Sorry about that.
Absolutely inexcusable. And quite frankly, sanctionable. Because you can't try to make somebody not do something by, quite frankly, as I'm listening to your explanation, are just absolutely unequivocally false threats to their livelihood.
I don't believe that's what I was doing.
What do you think you were doing?
Trying to bring to Ms. Hughes' attention an issue that may or may not exist. She interpreted it as a threat, which I understand.
I'm going to grieve your boss. And you.
I did not.
If you start this exam, she's supposed to take that as something that should be brought to her attention as opposed to a threat?
We continued our discussion a second time where I was explaining where I was coming from. I did not say what I said in a very artful way. So
You threatened a grievance for her proceeding. Am I wrong in that?
I didn't consider that I threatened it. I was trying to bring an issue forward. She took this threat.
She took it as a threat. What was she supposed to take it as?
She took it how she took it. I mean, it was a mistake on my part. I acknowledge that.
You're trying to tell this court that you didn't intend to threaten her boss and ultimately her? Is that what you're telling me, Mr. Bennett?
I was trying to bring the nature of what I saw as a potential issue. I unfortunately started it.
The issue being what? Their use of evidence pursuant to the court rule, which is why we have these hearings, why you have the ability to object, and then this court would have to rule.
All right. Yeah, I think that would be entertaining to watch, but I don't think that would be good. I don't want to see that. Attorneys spend a lot of time getting to the position of being an attorney, and to being taken out of court by Mr. Allen. Yeah, it would be entertaining. I would play it. Everyone would play it. It would go viral. But yeah, we don't want that. We really don't want that. That would not be a good thing.
I felt this case was different because this is not a situation where the alleged victim is given another detailed statement as to what happened.
And so what makes that different?
The duty to investigate the facts.
How do you know they haven't?
Besides her telling me that they haven't, I don't know.
I don't know who her is, but I've never told him the information. I've never told him about the many contacts that she's had with my office. I've never told him about, he's put on the record that she's been appearing at the hearings. Your Honor, she's been at hearings that Your Honor has presided over. The letter that was turned over to the police department was then turned over to the defense. And frankly, he has never asked me. He just came forward with, I'm going to grieve Ellie Savage.
Bennett, I am very concerned. What was your intent on saying that?
My intent in this.
You know, I'm going to stop you right now because I'm going to tell you something. You need to be real careful because I may have to consider grieving you.
I understand that, Your Honor.
And I don't think you want that.
I certainly don't want that.
So what I'm going to do is I'm going to take another about 10-minute break. And I'm going to come out and ask for your explanation before I decide on anything that I would do. But I will let you know, Mr. Bennett, with regard to what I've heard of the conduct here, you are walking on real thin ice, not just with me, but with your ticket to practice. Court's in recess.
All rise.
Woo! Judge Simpson dropped one. Okay, so now I'm going to say this. What this defense attorney, he just said, well, she perceived it as a threat. It wasn't supposed to be a threat. She perceived it as a threat. What Judge Simpson just said to you was a direct threat. That is what you just did to her. How do you take it? Are you going to perceive that as a threat? Does your mind understand that he just threatened you the same way you just threatened that prosecutor? And what sucks for this prosecutor is she's new. She's only been in Judge Simpson's court for, I'm going to say, less than a year. So get him, Judge. Get him.
You see it back on the record in the case of the people, State of Michigan versus Whitley, counsel is present as well as the defendant. Is there anything else regarding this issue that either side would like to say?
Your Honor, I'm going to self-report the violation under Michigan Rule of Professional Conduct 8.3 subsection A. I agree that I gave the inappropriate message to the prosecutor. I apologize for doing that. I feel obligated to report myself.
We will see if that happens because the court hasn't made a decision as to whether or not the court should report you. Mr. Bennett, I am going to tell you in all the years I've been here, counsel, and even when I was down in the trenches, counsels say things to each other, maybe not meaningful necessarily. They'll say things out of anger to each other. I don't know why you would even think it would be within the bounds of anything decent to make that kind of threat. And I call it a threat. That's precisely what you were doing. And I have to make a decision now knowing it as to whether or not I should do it. And I will make that decision. Ms. Hughes, and I'm going to apologize on behalf of the court for having to do this, but I think it's necessary given this turn of events. Would your lay witness, as well as I guess the officers, would they be available on July 1st at 10?
Is it at all possible to have the lay witness testify? It would be to identification. And I would.
As to identification of
the defendant. So it's very brief. And I don't want to have to bring the lay person back.
Understand. Mr. Bennett.
I would stipulate to the identification.
Okay. If I'm this defendant, I am firing this attorney right now. Right now. The second I walk out of here, like I no longer want you to defend me. I'm going to hire somebody else. I'm guessing he's hired because I've never seen this attorney before this case. So they've had a couple appearances so far. I mentioned one earlier. They never end well. There was one, he brought his assistant to like right behind the table, the defense table. And Judge Simpson yelled at him again. Like, are you an attorney? She's like, no. Well, then you can't be back here. This is for attorneys and defendants only. All right, and witnesses. But anyways, yeah, I would fire this guy right now. We're gonna stipulate to one of the things that the prosecution has to prove, which so he's stipulating to identification. So this witness was going to provide the prosecution with the identity, so his identity of being on the scene of that day. Like I said, there's a couple things the prosecution has to prove. One of them's location, one of them's identity. So you're just stipulating to it without asking any questions. It may have been a 2-second, pop up there and ask questions and whatever, and it might have been easy, but you're just going to stipulate to that right after that, because I feel like he's too emotional right now. So he's just going to stipulate to something. I'm just going to say I don't like that. So I would no longer be needing the services of this attorney if I was the defendant. Just my opinion.
So you're stipulating that the person that is sitting beside you is James Whitley and that he was in a relationship with Jennifer Potter on April 27th, 2024.
Yes.
Thank you.
Will that satisfy what that witness would testify to?
Yes.
Very good. Thank you.
What was the date? I apologize.
I am going to adjourn this, if it will work for everybody, to July 1st at 10 a.m. That is my only.
July 1st at 10 a.m.
I realize that gets close to a holiday, but will that work for?
Yes. Thank you.
Oh, that's fine. I will adjourn it. Mr. Bennett, please apprise this office as well as the prosecutor if you're going to self-report, so that maybe others of us don't have to take any action.
Yes, Your Honor.
Preliminary examination in this matter is adjourned. July 1st, 2024, 10 a.m. before me. Thank you.
All right. What is the over under on if this defense attorney actually self-reports? I feel like he's that attorney that'll just say anything to get him out of a immediate issue and not looking at the long term. So what's the over under? What do you guys think? Do you think he's going to self-report or not? I mean, I don't know if we'll ever find out. We'll see the next hearing if he does self-report. I don't know if they'll even bring it up. We'll see. Anyways, we're gonna kind of shift a little bit. The first two were judges yelling at the attorneys. The first one was not as heavy as that one. That one was we never see Judge Simpson that angry. We've seen him frustrated, but he generally shakes it off in about 2 seconds. He was mad twice. He had to take 2 breaks. Okay. So now we're gonna look at the next 2 ones are actually we're going back to Judge Gauthier. And we're just gonna watch some not the smartest defendants, out of the tool shed. That old saying. All right, let's go. You guys are all awesome. Thank you for hanging out with us tonight.
On the record and recalling People v. Justin Roth, file 23-6664FH. And Mr. Gilbert, what's our status in the case then?
Well, Your Honor, I attempted to talk with Mr.
Shut up. Is it your birthday today? No. I need confirmation. I am not going to play this video until I see you say yes or no. And if you say no, I'm not going to be very happy. Not going to be very happy. If you say yes, I'm going to apologize. So I do not. Happy birthday, buddy. Happy birthday. I knew you wouldn't just pull that. I was kind of teasing you. No. Happy birthday, man. Thank you for hanging out with us on your birthday night. He has been one of my best friends on the YouTubes for, I don't know, since I've started. I knew you before I even started a channel. And my channel turns a year old in about 2 weeks. So yeah, no. It's awesome, man. It's awesome. I wish I knew that. I wish you would have told me. I would have put together a montage for you like I did Heather. I'm just kidding. I wouldn't have done that. No, maybe I would have. I would have got Judge Gothier to sing you happy birthday. Oh man, if I had that kind of power, I'm serious. So happy birthday, man.
Roth, he would not come to any type of conclusion. Basically, was talking in circles with me. So we do not have, I don't believe at this time or anytime we'll be entering a plea.
Okay. Yeah, Mr. Roth?
Yes, Judge, I don't know a lot of what's going on still to this point. I've had a few different public defenders from that office there in Sheboygan, and the main message is the same. It's just the details that I have not found out about. Like I was told from the DWI that you reigned over with Jesse Williams that I had a felony from that, and that was the understanding from what I was told during the plea offer was made up. And if we went backwards and there was somebody that had a felony, yes, that would affect the plea agreement. But if we can check to make sure that I do not have a felony, as Jesse Williams has told me before we do anything, that would be great, because I don't even know if I have a felony. I'm under the impression I do not because of what Mr. Williams has said.
Hey,
And,
Mr. Roth, I can give you a clear answer to that question.
Okay, thank you.
Ready? Your habitual second notice alleges that you have a prior conviction of attempted resisting obstructing. That is not a felony. It's a misdemeanor. So you're correct that you don't have a prior felony. However, the Michigan habitual offender sentencing law allows sentences to be increased for habitual offenders if they have a prior felony or attempt to commit a felony. So attempted R&O, which is what you have the conviction for, is itself a misdemeanor, but because it is an attempt to commit a felony, the prosecutor has lawfully filed a notice to increase your sentence in this case if you're convicted as charged to a habitual offender second. Does that answer that question, sir?
Okay, so one was added, in other words, to one end, which is now affecting this end of it. So I guess the question is, why would you go back and mess with the other charges when they're piled on me right now? I guess that's the question that I would ask Gilbert, and we haven't discussed any of that. We haven't discussed any discovery.
He can't answer that question, and neither can I, because the only person that can answer that question is the prosecutor, and they don't have to. They have the constitutional authority to charge you with what they want to charge you with. Why they're charging you with that is completely and wholly legally and factually irrelevant. They have lawfully filed the habitual offender notice because you have a prior attempt to commit a felony. Why they've habitualized it, I don't know, and I don't care, and they don't have to tell me why. They don't have to tell you why.
Yeah, no, this guy does have an attorney. Why he's not asking the attorney these questions, I don't know. But his defense attorney is sitting there in person at the table. And again, you know, the old saying that I just brought up, that everyone's heard, not the smartest defendant in the shed, right? You know, everyone's been saying that since like the 1600s, right? Or did I just make that up? I think that's an old saying.
Okay.
So where we're at is that your jury trial is scheduled for August 29th and 30th. And what
I
we're
haven't
going to do
discussed
is...
this. I'm sorry, excuse me. I haven't discussed this plea agreement with my family. And they
I told you that today was the plea cutoff. I told you that.
Well, I'm not around family, and I have been traveling. I have not been consumed in my legal matters at all in the last month. And I always get last minute phone calls to discuss them. And it's just not right. The way I'm being fed the information.
All right. Well, Mr. Roth, your jury trial is scheduled for August 29th and 30th. And we're gonna have you come, we've been allowing you to appear by video throughout from even another state we allowed you to leave to. So that we can know that you're here back in town for the trial. I'm gonna have you appear at a docket call in my courtroom in person on Tuesday, August 20th at 2 p.m., 2 in the afternoon. And that's a little more than 1 week prior to the jury trial. So that way we'll all be present in the courtroom and can make sure we're all set for the trial. All right, you have any questions for me about that, sir?
Yeah, if I ever asked for another attorney at any point in time, would this go backwards at all?
Well, I mean, you'd have to give
And
me
would we
reason to
reevaluate
give you, you'd have to give me reason to give you a new lawyer, and I certainly haven't heard any
I
reason to
certainly
do
have
that.
given you reasons.
No, and I mean, Mr. Roth, I'll take judicial notice of, the prior case we had. I mean, I think I've already said you're a uniquely difficult person to deal with in the prior case, and that appears to still be true. And Mr. Gilbert is a capable and accomplished and experienced advocate, and he is your lawyer. He will be your lawyer for this trial. So, and it's going to happen on August 29th and 30th. And you will be physically present in my courtroom on August 20th at 2 p.m. Not by Zoom, but in person. Okay, do you have any other questions for me?
Yeah, I don't know if those dates are going to work out, but I don't have anything going on currently. It's just all depends on the seasonal travel of my family and what we're doing. This is not what I want to do, and I still want to discuss it farther.
Yo, you were charged with a crime. Why do people think that they can control the courts? You're the defendant, man. You're the defendant. You are there because you have to, go to court. You committed a crime allegedly. You're going to court. You have a jury trial because you're saying you didn't do it. You can't just keep pushing this out. Do you want a new lawyer? This guy literally seems so laissez-faire about this whole thing. Like, he's being charged with a felony. He's just like, oh, whatever. I'm gonna check with my family, and if they don't like the time, I'll call. I'll call the court. We'll just say we can't do it. No, it doesn't work that way. I think this is a product of Zoom court. I think defendants think they have a lot more control of the process than they do. No, go listen to your attorney, man. Go listen to your attorney.
Okay, well, you're charged with a crime. You can either plead guilty to it or have a trial. So, you haven't pled guilty to it, so we're going to schedule it for a trial. That's fine. You don't have to plead to it, but what you don't get to do is just make the charge go away because you don't want a trial and don't want to plead. That's not an option. And it does not matter to me whether these dates are good for you or not. You will be in my courtroom as I have ordered you to, or there will be a warrant for your arrest. So we'll see you August 20th at 2 p.m. All right, have a good day.
I understand that.
All right, and that concludes your matters, Mr. Gilbert.
It does, Your Honor. Thank you.
All right, and
Judge just hung up on him. He was in the middle of talking. I forgot he did that. Oh, sorry. I just burst out laughing real quick. Craig, thank you so much for becoming a new member. Welcome to the family, Craig. I appreciate you being here. Thank you so much. We just had a good members only Monday last night. So, but you have access to all the members Mondays now. Also, yeah, I peeps. I got it written down. Cloud illusions. You said that I wanted to reply to this, but I was going to wait till this finished. You said you can always feel me lurking. Yeah, I'm always lurking. But cloud illusions. Can anyone else tell me why this nickname hasn't kicked off? Cloud illusions. I call cloud illusions chemtrails, right? It makes sense, right? Cloud illusions, chemtrails. I mean, tell me it doesn't make sense. But it's not catching on. All right, next one. We're going right back to Judge Gauthier. Another, really smart person that called in over the phone. Let's go.
Mr. Wyrick. Oops, sorry.
Yes, sir.
All right, this is file 23-6762FH. You want to tell me why you're zooming in a half hour late after I already issued a warrant for your arrest for not appearing?
Sir, I've been trying to contact my lawyer since earlier. I had missed his call, and in between the voicemail, I try to answer, and it's just been a lot of misunderstanding today.
right,
And
well, here's what we're gonna
it's really
do.
no excuse.
We're going to fix that misunderstanding. You have lost your right to appear by video in my courtroom. You're going to have to be physically present in my courtroom next week, June 11th at 2 p.m. And we're not going to have miscommunications with you any longer.
Yes, sir.
So
And
2 p.m. 1 week from today, you'll be physically present in my courtroom. I'll see you then.
yes, sir. Can I say one more thing, please, sir?
Sure.
While it's on record, because I've actually contacted my lawyer multiple times, and I have not been able to reach him or talk to him. And also, I also asked if I can get this adjourned because I was trying to see if I can get a paid lawyer. This is my third lawyer I'm going through with because two of them has retired or something. I don't know. They're not on my case no longer. This is the third lawyer I have had to work with, and he doesn't know anything about my case for real. I haven't even been able to talk to him or anything. And I've tried to reach out multiple times. And I'm not trying to seem, and I've been trying to work with you guys. I'm trying to get this handled the correct way, sir. I don't want to run. I don't want to seem like I'm on bull crap or anything. And it's just a simple miscommunication that me and him could have. I just need to be able to communicate with my lawyer, and that's why I'm trying to pay one now.
Okay, so he reported to us earlier that he was trying to reach you and had a hard time doing that. So contact the public defender's office here in Sheboygan. Make sure they've got good numbers for you so that they can do that. And this is not the first time we've had issues with appearance for you. So we're done doing video appearances. So June 11th, 2 p.m. up here in person, and that way we won't have any miscommunications. You'll be here in person. You can talk to your lawyer, and we'll all be here and we can talk together and at the right time. All right. We'll see you then.
Okay.
Oh, that was today. I need to go back and see what happened. I didn't realize this happened today. Man, this hearing was on like a week ago. All right, I'm gonna go check that after this video tonight.
I just got one question. Well, can I get adjourned? Because I just want to get a different lawyer. Because I can't keep doing this miscommunication with this lawyer. And I just want to go on record while we're on air that I just want to get a new lawyer because I asked him, I even told him, could he get it adjourned? So I don't understand why he's telling you that it's miscommunication.
All right. You can hire a lawyer anytime you want, but you heard me tell you when you're going to be in my courtroom next.
Yes,
right?
sir. Yes, sir.
When is that?
The 11th.
Yep. What time?
At 10 a.m.
No, at 2 p.m.
Oh, I thought you said 10 a.m. I'm sorry, sir. 2 p.m.
It's all right. That's why I wanted to clarify it. No more miscommunications.
Yes,
June
sir.
11th, 2 p.m. We'll see you then.
Well, I'm going to have to come early anyway.
Okay, that's fine. Have a good day. All right, let's bring in Mr. Roth.
All right, so the funny thing is, I actually played those backwards because when he said, let's bring in Mr. Roth, that was the first guy I just showed you. They went back to back and they were both complaining about the same attorney. Just want to put that on the record. Maybe, you have two different defendants saying they're complaining about their attorney. Maybe the attorney needs to step his game up. I don't know. It could be 100% on the defendants because they both kind of seemed like they weren't too into the whole court thing. Anyways, all right, last clip. Hold on, did I miss something? I did miss something. Sparkle Poots, thank you so much for the 5 gift memberships. I appreciate it, Sparkle. And welcome to all the new members. Thank you so much, Sparkle Poots. I appreciate it. Glad I didn't miss that. Court is hard. You're right, Ranger. Court is very hard. Okay, last clip. Last clip of the evening. Now, this one, I was gonna hold off. When I got it, I was like, okay, this is gonna be my thumbnail clip of tonight's video because not a lot of people cover this judge. Not a lot of people do, and I watch him all the time because I like this judge a lot. And about 2 hours after this played, people in court put a video out. And I'm like, man. And then about 2 hours after her clip, Law Talk with Mike put it out. It's like, all right, now I can't headline this one. Everyone's seen it. So I'm just going to put it at the end of my video because it's still really good. It's still really good. Again, you may have seen this already, but for everyone who tells me I don't know what a Karen is and I keep calling people Karens that aren't Karens, please let me know if this is an actual Karen, because I think this hits all of the qualifications for one. All right, let's go.
All right, Ms. Lyons, you able to hear me?
Yes.
These are citations. They were issued on May 3rd of this year on 142nd Avenue there in Door Township. You have two citations. One is a violation of seatbelt law. The other one is for an expired plate more than 30 days. On these citations, you need to do one of two things. First is you could admit responsibility to the citation, or two, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or three, you wish to contest the tickets. In other words, fight the tickets at what we call informal hearing. What were you looking to do?
You know what? I missed all the Twat Wobbles assembling. So, all right. Is everyone here? I cannot play Balls of Steel unless all the Twat Wobbles are here. Can we confirm that all the Twat Wobbles are here? I counted 4 the last time I looked. I don't remember who I was with. I really don't remember. Yeah, I know. Isn't that special? What did I miss? What did I miss? I'm looking. I've looked. That's the second time you said that. I don't know what I missed. All right. Jedi says present. All right, Balls of Steel incoming, and I will look to see what isn't that special saying. Let's see. Twat Waffles. When all the Twat Waffles assemble. Let's go. There we go. Twat Wobbles have assembled. And Wixom coming in hot. Thank you so much. This is not a donation. It's a down payment on Colin's future LSAT, followed by law school. Thank you so much, Wixom. Thank you so much. Actually, I talked to Judge Fletcher about the LSAT today, and we're moving forward on it. We're moving forward. We just got to there's a couple hurdles I got to figure out. And yeah, gonna get with Judge Slavin in the next couple of days. Talk to him. Talk to Debbie Baker. I always want to say Debbie Davis. I need to start calling one of them Deb, because when I say Debbie, I instantly just blurt out a last name, and it's I got a 50% chance. But Wixom, thank you so much. That is a very generous super chat. Thank you so much. Sparkapoo, it's about dang time, right? About dang time. I appreciate it, Sparkle Boots. All right, I'm looking in to see what isn't that special. She said I missed something, so I'm gonna go look. So I'm gonna let it play.
All right. So the latter would be on expired plates, that your plate was not expired.
No, my plate was expired, and I had a ticket already issued that was less than 30 days old, and I've made 3 separate attempts to go to Secretary of State that had walk-in appointments, and they wouldn't take me. The plate has since been corrected. I explained this to the officer as he pulled me over in my driveway with my vehicle off.
We'll have a hearing. That's fine. Let's go ahead and raise our right hands. Swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
I do. Yes.
Ms. Lyons, it makes a lot more sense for me to start with the officer. He has the burden to establish to me why he was issuing citations. And then after that, you'll have an opportunity to either ask questions or testify on your own behalf, all right?
Okay.
And with that, Deputy, you want to pick up the narrative somewhere where it makes sense, explain the issuing of these citations.
Yep, on 5/3 of 2024, approximately 13:35 hours, I was working a traffic grant and I was sitting at 142nd Avenue near 18th Street in Door. I observed Miss Lyons' vehicle to travel eastbound on 142nd Avenue. I observed that Jody did not have her seatbelt on. By then, by the time I could catch up to her and maneuver through the construction, there's multiple cones on 142nd Avenue, so obviously there's some traffic going on, but by the time I could catch up to her, she had pulled into her driveway. I made contact with the driver. Obviously, I see her in the courtroom today as Jody Lyons. I advised her, I asked her if she knew why I pulled her over. She stated that it was probably for her tabs. She then explained to me that she had a ticket about 2.5 weeks ago for the license plate tabs. I advised her, I did notice that when I did pull her over, but the main reason I pulled her over was for her not wearing her seatbelt. She said, "Oh, sorry." After running her plates and everything, they came back expired on 3/24/2020. She did explain to me that her husband should have taken care of this and should have paid for it, and they should be up to date. I advised her, even if they paid for them online and she did not have them on her vehicle, they would still be up to date in my system. But I checked the lien and it came back still expired in 2020. And then she advised that she would take care of it at the end of the day, business day, after I got done with her. So I wrote her for a seatbelt violation and for her expired plate since it was expired in 2020.
And I just want to be clear, because I see the expiration date here, because it's birthday, 3/24, but of the year 2020, not 23 or 24 or anything.
Correct.
All right. And Ms. Lyons, what is it you'd like to tell me?
Ooh, she's got a lot to say. Before we get into her though, legal fiction. Thank you so much. I did not miss a super chat. I just looked. I think you guys isn't that special on your bandwagon of telling me I missed something, because I don't believe you anymore, but I believed her. I did, and I just went through. I went through all my pay apps. I went through everything. I couldn't find anything. So yeah, thank you so much, legal fiction, for the super chat, and thank you so much for getting other people to mess with my head and tell me I missed something. Okay, let's finish this up. There's not a lot of time left in this. There's probably only 2 or 3 minutes left of this clip. So you know what that means. I'm going to let it play out. I just looked. There's nobody on my, well, there's a few channels on my list that are live right now, but nothing court related. So I'm not going to forward us there. So you guys all have a great night. Thank you for hanging out. Thank you everybody for the super chats, the gifted memberships. Thank you so much, Legal Fiction, for the 20 gifted memberships. That was very generous. And Wixom for the huge super chat. Thank you so much. And everybody else, membership milestones, you guys are awesome. You guys are awesome. All right, we're gonna finish this up, and can we see 8 more? Can we see 8 more of what? 8 more videos? No, I think I have one video that I could possibly play, but let's see, hold on. No, I don't. I have nothing ready. I actually have nothing ready. I thought I had one ready. I don't. So no, I can't even do a bonus clip if I wanted to. Thank you, Spade. You missed Eric. You missed Eric Martin pick LF Drew. You missed Eric. I'm guessing that's Martin. You missed Eric Martin pick Legal Fiction Drew. Oh, he drew an Eric Martin pick. What is that? Like in the chat, he did that. Like he did that in the chat, or he like? Oh, yeah. I know. Spade. I knew you meant Martin. I don't have any videos. I have no videos ready. I just looked. I have the video I released earlier today. Then I have my live. I have nothing else ready. I can play you my soft sit video from this morning that I released. That's all I got. That's all I got. So can't do anything else. Unless you want to watch the soft sit that I've already released that I think all of you saw because it's doing really well for views. All right. I'm rambling. Let's listen to what this lovely Karen has to say, and then let's go hang out and play it. All right, no. You know what? I'll play it just for you, no. But let's finish this. Let's finish this clip up.
First of all, the expired plate ticket, I already had a ticket for, and it was not even 30 days old, and I had been currently trying to proactively correct that, which it has now been corrected.
And ma'am, what you're explaining may be some sort of defense if we were talking about anything other than a plate that's been expired for 4 years now.
It is
You
still
could get a
defense.
ticket for this every day that you drive the car.
But
You
yes,
can't drive your
except,
car without tags,
except there's a
right?
double jeopardy thing. How many times can you issue somebody a ticket? What the ticket I got was
Every
not
time
even
you
30
drive the
days
car,
old.
you could get this ticket, ma'am.
Yeah, all right. I did not want to pause this again, but everyone's already played this video. So, Aaron, thank you so much. I will pause for you. You got your own very personal pause, and this pause is actually going to get me in trouble because people are going to leave comments. Stop pausing. Thank you so much, Aaron. You are awesome.
Okay.
Every time.
As far as the seatbelt goes, I am 5'1", and my seatbelt, the shoulder strap, because my car is a 2003 Chevy Trailblazer, cuts across my neck. I wear it behind me, and that officer that pulled me over in my parking lot, in my driveway, saw me take that off. I went to get out of my car, did not even know he was there.
Okay, ma'am,
Saw the
I'm going to
light,
stop you there
shut my
just
door.
because anything that you're saying after what you already said is really sort of not relevant anymore. To
Okay.
have your seatbelt count as on, you have to be wearing it the way the manufacturer intended. Plenty of
Unless
people
I get
do what you're saying.
decapitated in an accident,
Ma'am.
officer.
Ma'am, listen to
Unless
me.
I get
Plenty of
decapitated.
people do that, and every time it counts as you not wearing a seatbelt. You have to wear
But
it
my
the right
seatbelt
way,
was
or it
on.
doesn't count.
And I was
No, it
in my
wasn't, ma'am.
driveway.
Doesn't matter, ma'am, because you were on the street before you pulled in your driveway. That's where he observed the
And I was
violation.
on the street with the belt part of my seatbelt buckled and the strap, shoulder strap
And ma'am,
behind
I
me.
want to be super clear with you so you understand that. That doesn't count as your seatbelt being on.
So if my seatbelt's on and I get an offender bender and I get decapitated, that's acceptable to you.
Ma'am, that's farcical. Farcical argument. This isn't even close. You are clearly responsible
I'm just
on
gonna
both
pay
of these
the ticket,
citations as
and
written.
I'm gonna
ma'am.
contact Channel 13 News on your side because this is bullshit. So I'll just pay the
Okay.
fine. Have a nice day.
Well, I can tell you your rights on appeal if you'd like to hear them.
No, oh, sure. Yep, I'm appealing all of this because this is crap.
All right. So if you disagree with what happened here today, you must do two things. First is you must ask for that appeal to formal hearing in front of the district court judges with the prosecutor's office. You must do that within 7 days. Your window of opportunity to protest further.
Someone needs to contact that Channel 13 and tell them, please take this woman's story. We need to hear this. We need to hear what she says to you. Please, just act like you're serious and then run it. You're gonna blow up on YouTube. But just listen to her, act like you're serious, and then just laugh at her behind the scenes.
Closes after 1 week. Secondly, you must come in and ask for that formally in person because you would need to post a cash bond in the same amount as the fines on any ticket that you wish to appeal. Do you understand your rights on appeal?
Yep, I sure do. I'll
All
be
right,
in
then
tomorrow
we're
morning.
all set.
Thank you. Have a nice day.
You too.
All right, that's all I got. Do you guys really want to see the soft set video that I already released this morning? No is the only one that said he wanted to see it. He wanted to watch it live. I kind of disappointed him in Judge Webster's court chat. But Channel 13 will tell her to kick rocks. Yeah, they will. All right, you know what? If Chemtrail says yes and no said yes, then I'll replay the soft set video. Retired Rachel, thank you so much for the $2 super sticker. I appreciate it. Thank you so much. Wait, is it? No, it's $3. I was gonna say, like, why did I say 2? And then I see like 99 next. So thank you so much. Andy Junction, thank you so much. Remember for 3 months. I want to see it too. All right. Everyone wants to see it. All right. Hopefully I still have the version where I'm not talking. So you don't have like an inception moment. Is this it? Hope this is it. What's going on? How's everyone doing? Yeah, I hope I have the version where I'm not talking. Inception moment. Yeah, here, this is it. And then you hear my intro with me still up here. All right, here we go.
Next, we can address Jonathan Schuster. This is for arraignment 4805-25748.
Come on up, sir.
All right, so I see a few people say that you haven't seen it yet. So this is what I'm going to say. After this video, please, you don't have to go rewatch it, but just jump on it, jump on the video, jump on my channel, find the video that I posted this morning. It was like at 9 a.m. Click on it and just hit the like button because the video is doing really well and I would like to keep it doing well. So I'm showing you guys this here. That's the only thing I ask. Peeps, thank you so much for the one gifted membership. I appreciate it, Peeps.
Go ahead and have a seat, please.
Peeps, I hope you're having a great night.
My honor. So for the record, I've made this special dissertation under duress pertaining to the matters of Jonathan Troy, Faifu Leaso Maliatoa Schuster. For I am beneficiary, I am sovereign, I am man, the flesh lives, the blood flows. I am a non-US citizen, American national. I am sui juris imperfecta persona. I reserve all rights. I do not understand the status. And so I ask you, ma'am, what is your name? What is your nationality and what is your status?
I'm Judge Grant. I am a citizen and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last two are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
that would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I've challenged the jurisdiction, and jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also going to be getting sued, it would just add to that. And I don't think that you need to go that route.
While I review this incident report. Okay, so this is authored by Brandon Carlsrud, signed under penalty of perjury.
That's a really good point, Andy. He should just take over. He should take over the course right now. Like, you know what?
All right, I do find probable cause.
I'm going to claim your job because you don't have jurisdiction and I do.
I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody.
No, other way around. He moved to dismiss and no. She didn't go to dismiss. He wanted to dismiss it and she said denied. Then he said object. I think he said I object multiple times so far. He says it like 10 times during this video. But no, you have it backwards, Raven. Oh, Raven, good to see you. I haven't seen you in a little bit.
That is, practicing bench from the law.
Unless you want to enter a plea of guilty today, there'll be a.
Oh man, I gotta rewind it now. You guys missed. I paused it right before the best line. All right, here we go. Listen.
That is, practicing bench from the law.
Unless you want to enter a plea of guilty today, there'll be a plea of not guilty. Understand you are objecting.
Ma'am, I object. I challenge the jurisdiction. Jurisdiction has not been proven. Status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-US citizen, American national by way of America Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but to look at ADR.
Hey, that's one of my favorite things to say. Whenever I suspect someone of being drunk in court, I always say, I swear to drunk, I'm not God. Nunya, get out of my head. I don't think this guy's not drunk. He's in
It
jail.
looks like
But
you have a driver's license that recently expired.
To question my competency because I'm evoking my, or not evoking, I'm sorry, establishing status and asking you to prove jurisdiction is outrageous.
all right, I said this morning. I'm interrupting a lot. I'm going to have to, because since I played this morning, YouTube will actually claim, like, even though I played the video and no one, like, I don't think I've seen this on any other channel, they will still copyright strike my own video. So I that's why I'm pausing a lot. But this is the outrageous thing, Mr. Sovereign Citizen. What a lot of people don't know is when you ask for a competency evaluation, that doesn't mean you're not intelligent. That doesn't mean that you have, mental illness going on. Does not mean any of those. It means that you can't assist with your own defense. Can it, encumber, you not being that intelligent? Can it encumber some MH issues? Absolutely. I don't know. Is encumber the right word there? I might have used the wrong word. But all that means is you can't assist with your own defense. And if you're bringing the subset defense, you can't, because it's not right. It's not true. So when sovereign citizens hear that, they think that the judge is questioning their intelligence. That's not at all what's going on. Or in this case, the prosecutor. Okay.
And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.
All right, I've reviewed this. You were driving in the city of Lake Forest Park. You were violating.
Again,
laws.
I was not driving. Again, I have rights.
You were behind.
And my rights were violated. My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so.
Yeah, and now I know I got the word encumbered from. He keeps saying it, so he put it in my head. That's where I kept getting that word from. And Heineken, good to see you, buddy. My best friend troll on the internet, who never has a nice word to say about me, but still my best friend. Heineken, good to see you. How's Turkey, by the way?
So again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor, I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance, as well as concerned about community safety and risk of reoffending, given his temperament in the court today.
And Your Honor, Mr. Schuster would ask the court to release him on his own recognizance. These are not violent offenses. I don't see that he has any convictions for violent offenses. There was an assault from 2021 that was dismissed. He may have a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would in any way try to subvert court proceedings. So we'd ask the court to release him on standard conditions.
Well, the court can consider whether or not Mr. Schuster is likely to reappear for future court hearings. What I hear from him today is that he completely objects to this court having any jurisdiction. I don't have a good faith basis that Mr. Schuster will return if I were to release him. I do see that he has a prior conviction for DUI. He's on a deferred prosecution at this time in Seattle Municipal Court. He's not complying with conditions if he's driving without a license and driving without a required ignition interlock device. Also indication that Mr. Schuster will not abide the court's orders to appear on his promise. I want to look at the Seattle municipal case and see when he's next scheduled to
Like you had mentioned too, in 2021, same situation, or not same situation, a situation occurred in which they tried to charge me. They didn't have jurisdiction. It was dismissed. And again, I don't want any charges against me because I do have the deferral, which would obviously violate that deferral. And so I will make any visitations, special visitations to the court to handle any matters pertaining to Jonathan Troy Faifale, also Maliatoa Schuster. I'm a man, I'm free, and I want it to stay that way.
I do see it looks like he's got at least 3.
Can anyone else tell me right now, is he free? No. Sitting there with his jail get up on and handcuffs. He's not free. You know, if you want it to stay that way, you're doing a good job. Because your version of free is no one else's. Everyone here in the chat and watching on YouTube, yeah, we're watching your version of free. So you're doing a good job if you want to keep it that way.
Prior warrants, he has 2 priors out of Benton County, 1 out of Lower Kittitas. The previous warrants history.
And throughout this process of going to courts, I've had to learn a lot. And so I know it's no game to just not show and make visitations. That's not what I want to do. And again, jurisdiction does need to be proven, whether it's today or another date. And if you want to violate my rights even further by not releasing me on my own recognizance, ma'am, was it Jennifer Grant? Then, like I had mentioned earlier, you, along with the officer and sergeant, who are already going to be getting sued, I mean, there's no need to add you as well, especially when you know the law.
I don't see another date set until February 12th of 2025 in the Seattle
Municipal Court.
Yeah.
Well, Mr. Schuster, I have to do what I believe is appropriate in this case, and that is to set bail. And any threats to sue me or to take any action against me, I can't be swayed by that. So
It's not a threat. It's just what it is. Because my rights have been violated, and if my rights are going to be furthermore violated.
$2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case, as well as the prior FTA history. So bail will be $2,000. If you're able to post bail, you are to return for your next court date. You are to have no criminal law violations. You're not to drive unless you have a valid license and insurance. And
When are you setting that court date,
as
miss?
required by the Department of Licensing. You are, you will be represented because I'm going to assign counsel.
I am sui juris in propria persona. I present myself. I don't need to be represented by anybody. I stand on my own 2 feet.
These are criminal charges that
I am so glad that I'm not the only one that's misusing words. He's representing. No, he's not he doesn't want to be represented. You know, like my now all I can think is encompass because that's the right word I should have said. I can't even remember the wrong word I said 5 minutes ago. Representing. I mean, I guess that kind of means the same thing. No, it means the same thing, right? You present yourself, or you have someone else representing yourself. No, that sounds kind of weird, but it says. But why do they pronounce words weird? Why do soffsets, die on that hill? Why do they pronounce words weird on purpose? I don't understand that. Someone needs to explain this. I said this in my video this morning. Someone explain to me what the purpose of pronouncing words weird is.
have significant consequences for you. So it's in your best interest to have counsel.
Again, I
assist
stand
you.
on my own 2 feet. I do not need to be represented by anybody. I present myself, sui juris in propria persona.
If you want to be your own counsel, you'll have to go through a full colloquy and waive all your rights to have representation. It's your constitutional right.
I do not accept being represented by anybody. Again, I present myself. I am beneficiary. I am sovereign. I am an American national, a non-U.S. citizen American national by way of American Samoa, like I had mentioned earlier. I reserve my rights, and I do not need to be represented by anybody.
All right. The time for trial expiration is 8/9/24.
Again, if you are practicing law from the bench and putting a plea in for me, I object to that. You cannot practice law from the bench.
Next court date will be.
Did you hear that? He just contradicted himself. He just said you can't practice law from the bench. You know what? I object. 10 minutes ago, he said you can't practice bench from the law. Okay. He's contradicted himself. None of this makes sense. I was following him until he just did that. You know what? Now he's going to stay in jail. Pretty sure the judge agrees with me.
We want to try for next Wednesday or even the week after that.
Well, next Wednesday is a holiday, so the 18th, which is pretty full. So I was going to set this on June 24th. That's 2 weeks out.
Yep, that works.
Hey, enjoy your vacation, man. All seriousness, enjoy your vacation. And if I don't see you by the time, you get back and you have your procedure, I hope that goes well as well. But yeah, be good, bud.
So for the record, you have not established status. You have not proven jurisdiction, and you're denying my rights. Is that correct?
I don't know what you think would establish my status, but I do have status to sit in this court.
You are a U.S. citizen. A U.S. citizen cannot sit a bench.
Sign for your next court date.
You're asking me to sign something that you pleaded for me. Is that correct?
I'm giving you notice of the conditions that I have set as well as bail.
You said yes, you pleaded for me?
Probable cause. If you are able to post that bail and get out of custody, those are my expectations that you will come back on that court date and that you will abide by the conditions that I have imposed. Those are being ordered today. So that is what's happening today. And we are giving you that notice. You can refuse to sign that notice and we'll note that you were provided a copy in writing and that you refused to sign.
I do not understand.
Which part of it do you not understand that you have a
I
piece
do
of
not
paper
understand how
with
you can
the
practice
document?
law from the bench.
I'm the judge and I am setting the conditions.
Well, you also entered a plea for me, correct?
What we're doing at arraignment is the plea is being entered. You're not pleading guilty, so on your behalf, I'm entering a not guilty plea.
So, correct, you
cannot-
are pleading for me,
There's
correct?
two pleas.
And if you
Not
plead for
guilty
me,
or
you're
guilty.
practicing law from the bench. You cannot.
Okay, someone had the best comment this morning, and I can't believe I didn't think of this. I don't remember who it was. If you're in chat or if you watch this video later, please let me know who it was. I'm gonna have to go back and look. But they said, if I don't have jurisdiction to hold you in jail, I don't have jurisdiction to take you out of jail. I was like, oh man, we need to get that line circulating because that's perfect. It's kind of like you don't have to give me your name to go to jail, but you have to give me your name to get out. It's kind of the same thing. It's like spot on. All right, let's keep going. I'm gonna finish this video. Actually, I'm gonna let it play out. You guys are all awesome. Thank you so much for hanging out with me tonight. All the super chats, gifted memberships, membership milestones. You guys are all awesome. Let's go hang out on Discord after this. And yeah, I will see you all tomorrow. Until next time. Bye.
Practice law from the bench, so I object.
I'm going to give you that piece of paper and we're done with your hearing today. We will see you in 2 weeks. Okay? All right.
Jennifer Grants, you will be
Okay.
taken further.
Here you go.